Hello, everyone. Good afternoon. Yes, afternoon. Thank you so much for joining today. My name is Victoria Watkins, and I'm here to talk a little bit about intellectual property, generally speaking, but also how it is a great value booster for businesses, certainly entrepreneurs, but also large businesses, small businesses, large businesses, businesses of any sort. So I hope you enjoy. Please let me know if you have questions, but we'll also have questions, time for questions at the end. As I mentioned, my name is Victoria Watkins. I'm a lawyer here in Chicago. I have a private investment deal sourcing firm. So what we do is we help investors find private businesses to invest in, and we do the diligence for them on the opportunities that they're interested in. So that could be in healthcare or lifestyle companies. It could be in entertainment or media companies. It could be in professional sports. It could be in pretty much any business that the investor is interested in. We will find those opportunities for them and then do some diligence to make sure it's a good opportunity. So that company is called Enrichment, INRICHMINT, in being rich, where the money is made, MINC. But when I used to be in this classroom, because I am a DePaul Law alum, I thought that I was going to be a fashion lawyer. The economy at the time when I was graduating said that I should pick something else, which led me into government. But I still continue to do consulting and counseling in intellectual property, fashion, music, entertainment, and things like that. Which also was very pivotal in me building my blog, which is the Baffle blog. So I'll give you a little more information about that at the end. But as I mentioned, I worked in government. I had the great pleasure of working for the state of Illinois and the city of Chicago during Rahm Emanuel's 2 terms as mayor. In that time, I was legislative counsel, so I was a lobbyist, literally working on behalf of the people in Chicago in Springfield. And the last year and a half of the administration, I was senior advisor. So that's a little bit about me. It's also very weird for me to be standing here in this room versus sitting on the other side, but it's better this way. So as I mentioned, we're going to talk a bit about intellectual property, generally speaking first, to just set the stage. So there are 3 main types of intellectual property: copyrights, trademarks, and patents. Very often, these terms get moved around and used in random kind of ways, but they all mean very distinct and different things. So when people say, "Oh man, that's a great book you wrote. You got to trademark that." No. "Oh man, that logo is nice. You got to copyright that." No. So, or, "Oh, this is a great invention. You should get a copyright on your invention." No. As you can see here on this chart, copyrights are protections of original works of authorship, because intellectual property, generally speaking, is a protection. Intellectual property is a creation of the mind. So the same way that real property is an actual item, intellectual property is something that you create with your brain. It could be creative in the sense of art, or it could be creative in the sense of an invention. And copyrights protect kind of the most artistic forms of intellectual property. So it's original works of authorship like books, songs, sound recordings, literal paintings, things of that nature. And there's also, as I mentioned, my fashion law of experience, sort of designs and sort of not, which is a whole rabbit hole we won't go down. But then there's trademarks. Trademarks are signals of sourcing and quality. So you would have a trademark for your business because the name of your business or the logo of your business, or maybe the tagline is something that you would trademark. And it gives you an indication of what those goods or services are and where they came from, and also an indication of the quality. So copyrights are good for the life. When you register them, they are good for the life of the author plus 70 years. Trademarks are good as long as you use them. So because trademarks are an indication of sourcing in the marketplace, the more you use them and the longer you use them, they continue to be valid and don't have an expiration unless they become abandoned. The other type is patents. And patents you use for inventions or designs that have some level of utility. So I pointed to this clicker here. I'm sure when this was originally created or whatever item it was derived from got a patent on it because it needed to be protected so that no one else could copy the design. What happens often with patents, because they, like copyrights, do expire at some point, is that you would use a patent to really build your business for a while, and then once it expires, then other people can use it to then kind of build their business. So they create a common good, but they are very helpful for you when you first get started in creating something that is not only different and novel, but has an everyday or a common use of some sort. So hopefully this chart is pretty helpful to give just a high level understanding of the three different types of intellectual property. Also, as I mentioned with like registrations and how long the registrations are good, registrations can be done at either the mostly the federal level. There are some state level registrations that can be done, but the ultimate registrations and the best ones are at the federal level, and then you can also do some international registrations as well. But starting with the federal level is the best way. Copyrights are registered through the Library of Congress in the Copyright Office, and patent and trademarks are registered through the U.S. Patent and Trademark Office, or the USPTO. So how do you execute the protection of your intellectual property? There are several ways to do that. As I mentioned, registration is absolutely important. The first thing I have here is to register your trademarks. And the reason why that is important is because you want to build, as we say in business, a moat around your business. And that one includes ways that make your business very unique and creates its own lane. And having your trademarks, which is an indication of your business in the marketplace, is one of those important elements. I would also certainly suggest registering your copyrights as well. The thing about copyrights is that as soon as you create something, technically it is immediately copyrighted. And the good thing about that is that, again, you have immediate protection, but it is definitely worth it depending on the type of dissemination you're going to do with your work of authorship. That you do take the extra step in registering it with the Copyright Office. That's really important because you want to have all of the tools that you may need to protect yourself if all of a sudden you find out that somebody is using your work without permission. And that's when things get sticky. So registration is very important. It's the same with patents. You want to make sure that they are registered as well. And the process for each, as the works of art are all different, is different as well. But it is really important that you start taking those steps. And certainly, if you are not legal counsel yourself, seeking legal counsel to help you do these things. You also want to be sure that you record your intellectual property with customs if you are going to be utilizing the international marketplace in any types of ways. This is definitely important from a trademark perspective as well as patents. Not that it's insignificant with copyrights, but again, copyrights, you get a lot more automatic protection, and there's things you can do by just writing copyright, the year with the C in the circle on your documents until you can get it through the copyright process with the Library of Congress. So you have a little more autonomy with copyrights. And a tad bit less, but still some with trademarks, because with trademarks, you should be using the little TM superscript until you can get through the registration process, and then that will authorize you to use the R. But either way, with all three types of intellectual property, you want to consider whether or not registering them with customs would be important. You also want to utilize the open market on the internet. So that includes social media and certainly at minimum, like protecting the domain names of your business. So you want to register the domain, you want to get it as .com and .org and .net, et cetera. This can be a little bit pricey, but probably not as pricey as if someone steals it and then is directing people to their page when they should be coming to yours. So that's something very important to consider as well, especially now with social media. There's so many different platforms, and so you want to be sure that you can get the social media handles that would reflect your brand, even if you are not going to be present on that platform. You don't want anyone else to take it. So these are little, as far as social media, these are little free things that you can do to make sure that your brand is protected. And of course, you want to definitely make your products hard to copy. So with trademark, with copyright, that could be a little different because the level of uniqueness is not the same as it needs to be with a trademark or a patent. I remember learning, maybe in this room or the one next door, that you could really draw a line on a piece of paper and say, this is my work of art. It is beautiful, and I am going to get a copyright on this. And then someone else can be like, well, I'm going to draw 2 lines, and they will feel like it's beautiful, and they're going to get a copyright on it. With a trademark, the level of scrutiny is higher. It is something that needs to be fanciful and novel. So that means something kind of different and unique. Like, think of the word Google or Xerox, Kodak, words that are now in the common lexicon, but had not been everyday words until they entered the marketplace. Those are things that the U.S. Patent and Trademark Office will look at. From a name perspective, if you're gonna trademark a name, they will also look at the uniqueness of a design of your logo. So you wanna make sure that you have something that is hard to copy and that is not very easily recognizable in the public domain before you make your registration, because the trademark office will say no. So be original and be unique. And you want to also get your whole brand involved. So as I mentioned, you want to get the domain name and you want to get the social media handles. You want to determine if you need to if you need to trademark colors, because you can do that. So if you are maybe Tiffany's and you have a specific shade of blue that you want to be recognized as yours in the jewelry space in the marketplace, then you want to make sure that your color is trademarked too. Or if you have a certain sound that is unique. I think we all hear that Netflix sound often, or the Microsoft sound, and all these different recognizable tones. There is protection on those. So we have a question?
Yeah, my name is Braden. Thank you for being here, first of all. I just was curious to know how trademarking a color technically works. Are you trademarking the hex code, like the little 6 characters that make up the color, or is it the RGB formula? What's being looked at? Because I also feel like those colors, or both of those classifications, there's a finite way of calculating a color, right?
Yes.
So the trademarks, I think you mentioned, those last indefinitely. And so I'm just kind of wondering how that's calculated, and then longevity wise, what does that mean for only so many trademark options for a color?
That's a great question, and I'm glad you asked. So with trademarks, you are registering your logo, your name, your sound in certain classes. So we'll stick with Tiffany's, and then we'll also do Louboutin, because that went a certain way. Correct. As you mentioned, there are kind of only a certain number of finite colors that can be created. We can do different mixtures, but there's only a certain number of colors. And obviously Tiffany cannot have command over that blue in just every aspect of life. If those chairs, if the chairs in here were that color, I think we would all know that they were not Tiffany chairs. So when you are registering for a trademark, you are registering that trademark in a class or multiple classes, but it is so that you can have command over that logo or that name or that color or designation, or what we call trade dress, in a certain space. So another example of that is the same way that we can have Ford models and Ford Motors. I think we know that Ford Motors is not going to help with any fashion shows, and Ford Models is not going to be creating any cars, because their trademarks have been filed and approved in certain classes. And there's a bunch of classes that you can choose from. You can choose multiple classes when you file your registration, but the trademark examiner will determine if you can, which ones you can get, which ones are reasonable to the business that you're building. But that's a really good question, because yes, if you were particularly doing something like a color, which is, they're pretty finite. Same thing to some degree with sounds, and many other things like that, that we can only kind of create a certain number of ways. You would be filing for those designations and those protections within certain classes. As I mentioned, I would talk about the Louboutin example, because as we know, Christian Louboutin shoes are red soles on the bottom, right? But the grant of their trademark is for a red sole in contrast to the rest of the shoe. So there was a lawsuit, probably I think like maybe 10, 15 years ago, where YSL had created a line of shoes that were all monochromatic. So the entire shoe was blue, the upper, the sole, the inner, all of it. The entire shoe was yellow, upper, sole, inner, entire shoe was green, and then they had a red one, and everything was all red. And so of course, because you have to protect your intellectual property very jealously, and you have to be very diligent and vigilant about it, Louboutin was like, oh, no, that's a red sole, that's ours. And so what happened was, when they filed their lawsuit, this goes through the courts, and the determination was that YSL did not violate the trademark of Louboutin, because what they created was a monochromatic shoe. It was not a shoe with a red bottom that was in contrast to the rest of the shoe. So again, with trademarks being an indication of a brand or a business, or what the quality would be in the marketplace, it is reasonable to think that if you saw that all red YSL shoe, that you wouldn't think that it was a Louboutin, because it was fully red. If you saw a shoe that was multicolored or all black or anything else with a red bottom, then you would think like, oh, that's got to be a Louboutin. So that designation helps to clarify. The very good question that you raised, which often comes up, is like, do people get a monopoly over what they register for just everywhere in life? And that's not the case. It has to be within the classes, not only that you apply for, but the classes that are granted to you based on your application, that the USPTO will approve.
Thank you.
Mm-hmm. So how does this translate to business? As I mentioned, it is extremely important to protect your intellectual property. The Louboutin example that I mentioned is a good reflection of that, because they were on it right away with the line that YSL had. Like, oh, no, you can have that all blue shoe, you can have the all green one. We got a problem with the all red one. And of course, they did not win that lawsuit, but the good part is that they were that protective of their intellectual property. And it is not a luxury to protect your intellectual property. It is an essential. You absolutely have to do it, because the risk is too great. So as I mentioned before, your intellectual property reveals who you are in the marketplace, and it also maintains not only your reputation in the marketplace, but helps to create and increase the value of your business. So it's very important that you are conscious about being clear on what needs to be protected within your business. So maybe your business has something that includes certain guides or books or other written publications. You want to be thoughtful to protect those with copyright. Um, if you have certain elements, as I mentioned, for sure, your logo, or as we talked about with trade dress, the Tiffany blue. So the boxes all look a certain way. They are a certain color and they have Tiffany written on them at the top in the center, not at the top, not at the bottom of the lid, but in the middle. It all looks the same. So that when you see something in the marketplace, you know, oh, I know what that is. And I also know that because of that, this is my expectation that should be met. So you want to be very thoughtful about it because it can contribute to the literal valuation of your business. And a valuation can be based on many different things. It can be based on cash flow. It can also be based on the current state of your balance sheet, which is an assessment of your assets and liabilities. It can be based on different revenue streams that you may have. So maybe you have subscriptions, or maybe you have a product that has to continually be refilled. So, you know, a consistent revenue stream in a health and wellness company, if it's shampoo, well, people have to keep buying that over and over. Maybe they're buying it through subscription. Maybe they buy it every other month because that's how long the bottle lasts. There could also be other ways that you are producing revenue. And we'll talk in a second about a couple of those options. But these are things that all create the value of your company. And if at some point you are looking to either sell your company or merge it with another business, you need to know how much your company is worth. And this is how much money we have in the bank. This is how much money we are expecting on a weekly basis, a monthly or quarterly basis. And also these are things that we have that help us produce money and keep our reputation at a certain level in the marketplace. And the reputation is definitely where intellectual property comes in. So as you grow your business, as I mentioned, there's different ways that you can increase the valuation of your business. One of the main ways that you can do that is through licensing. And so if you have a certain product, like for example, I have a lot of fashion examples. Bill Blass at one point, and also Calvin Klein licensed basically their logos and some of their designs to other companies that produced items that would then make them appear to be produced by Calvin Klein or Bill Blass. So for example, luggage. Calvin Klein doesn't specifically make luggage, but he partnered with another company that produces luggage so that people could buy Calvin Klein luggage. And what happened there was that the luggage company was able to leverage the goodwill in the marketplace of the Calvin Klein brand so that both of those companies could win. Like, I don't know if I would want whatever kind of luggage, but I would want some Calvin Klein luggage because I have other Calvin Klein items. I know that there is a quality there, and so I would be more likely to buy Calvin Klein luggage than a luggage brand that I don't know, even though that could be the luggage company that is partnering with Calvin Klein. So that is a way that both brands can elevate themselves and create more that's a new revenue stream, as I mentioned, and it also supports the valuation of both companies. The other way is through partnerships. So although the luggage example is a partnership, let's say we don't know what the luggage brand is, that seems to more so benefit Calvin Klein. But if you take two brands that are collaborating, so for example, Dapper Dan, who originally got himself in a lot of intellectual property trouble because he used to take the logos and monogrammed patterns of very popular luxury companies and use them to design his own clothing. He got in a lot of trouble for that, despite how nice the designs looked, because of course those companies were very vigilant and protective in keeping the purity and distribution of their logos very protected. So what happened later, fast forward probably 35, 40 years, Dapper Dan had a partnership with Gap where he created hoodies and other garments to match designs that he had created under the Gap label. So some of them were hoodies and they said DAP, like short for Dapper Dan, but it was done in the same logos and trade dress settings that you would see a regular Gap hoodie. And in that sense, that's a partnership because we know this is benefiting Gap and we know their reputation in the marketplace. And we also know Dapper Dan and his reputation in the marketplace, that he can take something that we know well and elevate it. He can take something that we know well and kind of remix it and make it look a little different. So that's an example of a partnership. Got a question?
Yes. I was wondering, like, for partnerships, would there be a concern, like the two brands would confuse each other, especially when they promote their own products and own brands, and people would kind of like associate the two together. So would that be a kind of confusion in the market?
There could be confusion in the market with partnerships, but that is why it's really important for both brands. The best partnerships are when both brands have their own lane originally, and then when they come together, it is so clear that this is a partnership and one side can't dilute or compromise the other because they still have their own lanes. It certainly can happen, and I'm sure has happened, where there was confusion or one brand ended up tainting the other. And that could be for a lot of reasons. It could be because like the CEO did something and that has nothing to do with the products, or it could be because maybe one of the products failed in some sort of way. So there's definitely a risk in partnerships on both sides because you kind of don't always know what is going to happen, but the best partnerships are ones where each business already has such a standing in the marketplace that you can see them separately as well as together, and them being together doesn't compromise either of the other brands. But there's definitely a risk, yes. Yes.
We have a question online.
Yes.
Hi, good afternoon. My name's Akila. I was wondering, in the discussion that you're having with licensing and partnerships, I guess, does that have any like changes when you add in real estate? And the example that I'm thinking of is like the Porsche condos in Miami. I'm not certain offhand if that was a partnership or a licensing agreement, but in a situation like that, would it, if say that's just a licensing situation, are you still exposed to the same level of liability as if it were a partnership because it's real estate?
So in the real estate, let me take a step back. All of these things should 100% be done with a lot of paperwork. And that doesn't necessarily mean many sheets of paper, a lot of pages, but there should be a lot of discussions and a lot of ironing out as far as who is responsible for what. And so the fact that that real estate is involved doesn't necessarily make it more risky. It just changes the risk because now it is a real estate, it's more of a real estate deal, which has its own level of risks, separate from if it is a clothing brand deal, which also has risks as well, but they're just different. With the Porsche condos that you're talking about, my guess is that is a licensing deal, or more specifically is a naming rights situation. So most often with naming rights, the company that has the naming rights is literally for them to get marketing. They don't have any responsibility on anything that like happens in the building unless they do. And that's something that should be very clearly laid out. It doesn't have to certainly be laid out for the public to know, but that should be laid out because if on the back end, if Porsche owns that building, sorry, Porsche, I should be saying, if Porsche owns that building, they then have responsibility because they are the owners of that building. And so they need to have insurance, et cetera. If Porsche is just in a licensing deal with the owners of that property and they are just paying for basically advertisement, their responsibility for that building is completely different. So there are different elements, I would say, that need to absolutely be addressed and ironed out when the licensing or partnerships have to do with real estate, but that's because they are real estate deals versus clothing deals or food collaborations or any other industry. So the risk is more so industry based, not specifically because it's a partnership or a licensing deal. Is that helpful?
Yes, thank you.
Okay. Any other questions before I go on?
Nope, that's.
Okay. Okay. So I got you, and thank you, Akila. I'm glad you also asked that question because y'all are like getting a little bit ahead of me, but it's all good. It's all good. It's a conversation. But what is absolutely important is making sure that you have very able counsel because none of these things should happen as a handshake or the wink in the gun or anything like that. You want to make sure that you have everything laid out. For one, because to the question we had earlier, you do want to make sure that the brands are not in any way compromising each other. So that may mean that we can talk about this partnership in this space, but it cannot be discussed in this other space. We can promote it on one platform, but we can't promote it on another platform. And I'd say platform not necessarily meaning social media, but it may mean that if there is a partnership between, let's say, a massage studio and a doctor's office, we can promote that on social media. We cannot promote that in each other's written documents. We're not going to talk about this partnership on patient forms. We are not going to talk about this in either on certain platforms or in certain spaces, so that there is no compromise of either of the businesses that are involved. And certainly when you are adding other elements like things that can have either great advantage or great harm to people, like real estate or like food or other products that we ingest or put on our bodies, you do want to make sure that you have everything very clearly laid out, not just in where the partnership or licensing deal is being promoted, but who is responsible for what? How do we get to the end point of what we are trying to produce? We want to, promote this, whatever this partnership is, and this is potentially for a short-term partnership. Is potentially for a short term, not something that's going to go on forever. This isn't necessarily a merger, which is a completely different situation. If we are doing a short-term partnership, neither company wants to put themselves in a situation, certainly just off the sake of any limited deals that would compromise their company or their valuations in the long term, because you still have a business that you are running outside of these short-term partnerships. And short-term can be a 5-year deal, but in theory, you would think that your business will last much longer than this partnership. And you always have to be considering what is best for your business without the additional revenue streams and partnerships that you may be doing. So contracts are extremely, extremely important. So what else? We talked about copyrights, we talked about trademarks, and we talked a little bit about patents, and we talked about trade dress, which is how your trademarks are presented in the market. Trade secrets is another one that you may need to consider. One of the most popular trade secrets is the recipe for Coca-Cola. That is literally a secret. So there is no registration of that recipe because, as I mentioned, it's a secret. Certainly it's something that people can try to reverse engineer or copy. but it is another tool that can be used to increase the valuation of your business. That can be the same for other elements, not only recipes, but it can be it can be just as useful for different aspects of your business that would make it, again, have a moat around it so that it's not easily copied or can't easily be used in a way that is separate from the use that you designate. Because intellectual property is supposed to give you a monopoly on the distribution and presence in the marketplace of what you have created and what you are producing. And so trade secrets is actually, you know, a very helpful one because you don't get to share anything about it. People just get to enjoy it. And you, of course, may have to end up sharing it in certain ways, whether that is for particular partnerships, or if you're going to have a merger or acquisition, you would need to share it at that time too. And at that point, you certainly want to have a non-disclosure agreement or an NDA. Because that is something that is very valuable and you would not want your trade secrets to be released. But again, the hook with a trade secret is that it's literally a secret. It is, in addition to other aspects of valuable intellectual property, which fall under the main three. Other things that would be considered valuable would be data. And we live in a big data world right now, especially because you can get so much information from social media, from your customers. You can get email addresses, you can get phone numbers, you can detect customer trends, and many other aspects of what would make it helpful for certainly your business because this information is yours, but it could be helpful to other businesses that might be your competitors. So again, this is information that you want to protect somehow. Not necessarily, it's not like you can say that you're going to, you know, get any formal IP protection on, you know, the email addresses or the phone numbers that you have. But what you can protect is the means that you use to get them. So I know there are many companies now that are creating their own unique AI tools, not using ChatGPT or using Gemini, but creating their own tools that help them. So that's something that they can patent that information. I mean, they can patent that tool, but the information that it holds is something that could be also valuable and would be easily sellable if they were going to either enter into a partnership or get to the point of a merger or an acquisition. So again, these are things that have quite a bit of value, and you want to be very conscious of how you protect them within your business. With a lot of data, it kind of depends on the value based on the business that you're in. So if you are in like a consumer goods business, if you have thousands or even millions of email addresses and phone numbers and things like that, that's very valuable because you can reach a lot of people. But if you are maybe in a professional services business, let's say you're an agent and you have like the top 3 or 4 movie stars and athletes' phone numbers, that might just be 12 contacts, but they are very valuable contacts. So the value is not just based on the quantity, it's based on the quality as well. So as you are assessing your business and where your valuation is coming from, in addition to, as I mentioned, the revenue streams and the cash flow and balance sheet, your data set is also very important to consider for value as well. Yeah.
Okay. Question about consumer power and ownership. Say you have 100,000 consumers out of 1 million on a customer list who realize that them possibly being solicited is valuable because they might just be interested in the product, but they don't want their information shared. How are laws kind of structured to protect consumers? Does it vary by the industry? in which the business exists saying you must ask the consumer whether they want the data to be shared, or is there a blanket kind of law that we progress to now that we're in such a data-driven world that says everyone, regardless of industry, must have the option to say, hey, you can use or sell my data or something like that?
Yes, so the answer to that is both and a bit of neither. And for the folks online, the question was whether or not there are laws that cover sharing consumer data across all industries, or if it's industry specific. Like I said, the answer is yes and neither, and also at the federal level as well as at the state level. So there are, in fact, federal laws and state laws, which would be patchwork because it's not necessarily in every state, that protect consumers in certain areas, specifically, for example, in healthcare, certain data that can or cannot be shared about someone as a patient. So if I go to my doctor's office and I give them necessary information to give me care, there's a lot of information that they cannot share because that is, private protected information. There's also what we call material non-private information, which is information maybe more so like your address, which is not as private as we think it is. It's material though, it's important information. It's not your diagnosis, and in theory, your address is not private because you get mail and people can walk and drive past your house. They may or may not know that you live there, which makes it material, but not necessarily private. So there are designations in different industries as far as whether that type of information can be shared. As you mentioned, where we are as far as social media and the type of information that many people are putting out onto the internet themselves, it makes it a little more difficult. But there are laws at the federal level as well as at different state levels on information that can and cannot be shared by choice. So you'll see on a lot of the social media platforms as well as other websites where when you sign up, you get to say, please do not share my information, and you get to click that box. You also have to be conscious. There was a website, I won't mention, that I was getting something from, and you get to choose send me more information from this entity, and you can choose send me more information just in general. You have to be thoughtful enough to not click those or to click them, because then now they can flood your inbox with many other things. And granted, that's probably just your name, email address, and phone number, but they could also sell that information. And there are laws that restrict selling of certain types of information as well. There are also certain laws that say different business types and different industries have to be sure that they give you the option or they present the option to you, please do not sell my information. So that's why, as I'm sure you guys learned here, you guys who are in the room in the law school, the answer is it depends. But just based on, as you mentioned, the world we're in now with so much data being out there, there are more and more laws that are being filed at both state and the federal level to protect people, because 10, 15, certainly 20 years ago, we had no idea what it meant or what the consequences would be down the line of putting our email address in somewhere. And now it's like, I can't get off this list. They will not leave me alone. They've sold it to 100 people. I don't want more emails, among other aspects of data. So, so yeah, there's no one blanket answer on that, but yes to some. Yeah.
Oh, we have another question online.
Yes.
If you want something to remain a trade secret, would this information still be needed as part of a trademark or other IP application? Are there modern ways to protect against this when it comes to providing information on government submissions?
So if you have a trade secret, there is nothing that you would be registering about it. So you would use a trade secret for, again, I think the recipes are probably the best example. While if you are going to be selling something in the marketplace, you do need to be able to share what the ingredients are. that doesn't say how much of each necessarily, which is how the secret gets to remain actually a secret. But if you do need to make certain government filings, there are ways that you can disclose to them that this part of it is a secret. So you can have formulas that get patented, but you would disclose not the actual secret, but that part of it is a secret. Otherwise, it literally is something that should not be disclosed at all, literally because it is a secret. So the government is aware, and through your filings with like patents and trademarks, if there are secret elements to it, more so with patents, that would be disclosed on the application. But with trademarks, there wouldn't be anything that you would be disclosing to them that would be secretive, because trademark is supposed to be seen in the marketplace. That is supposed to be something visible. Yes.
Yeah, could you touch a little bit on how you actually would then come up with a value for IP as part of a larger acquisition? You meant like if you have, someone who's established in an industry and they're buying up high growth companies as they jump into the same industry, and there's obviously an enterprise value of those companies.
Yep.
They might also be bringing new IP with them that would not be reflected in an enterprise valuation, and they don't want to give that away.
Right.
But then there's obviously that misalignment of, well, what do you offer and what do you want for it? Is there a way or
Yeah.
method of calculation for that IP component?
Yes, so there are several ways that you can do what we call an IP audit. And it is based on, I'll just go back to the list a little bit. So a lot of it is based on cash flow. And it is the connection between seeing that it is this item with whatever this logo is. So we'll just say for like the example of like a consumer good, whether it's we'll go back to shampoo or even a car. Oh, I know when I see this logo that this is what it is compared to others in the marketplace. So you can buy, Akila mentioned Porsche. You can see the Porsche and there's another car, we'll say an undisclosed brand that basically is exactly the same. The model is the same, the safety features. I mean, pretty much all cars have the baseline safety features at this point, but people are buying a certain number more Porsches than whatever their counterpart is for a reason.
Sure.
So Porsche would be able to go into their meeting about a merger or an acquisition and say, this is what we're bringing to the table based on this. Our cash flow is this. People have another option. They're not choosing it. They're choosing us. It's this many people. It's the same, again, like with the revenue streams. We could be in this one example will be good for like we'll say like a wellness or consumer company that maybe starts off with just shampoo and conditioner. Well, we know now that people will buy it because it's ours, and we've included lotion, and then we've also included shower gel, and we have a bar soap too. And then we're also gonna add travel sizes. Now that we have all these additional revenue streams, that has increased our valuation, because when people first saw the shampoo and conditioner and we made a name for ourselves in the market based on that, of course, they're now gonna buy these other items. And when the balance sheet, which is the other item, shows that like this is literally the case, then the business will have a way to show that their intellectual property matters. It also matters greatly from a patent perspective. That's why I mentioned early, like you want to work early on your patents in a way that I would not say taking as much time on a filing for like a trademark or a copyright, because you can protect those yourself a little differently than you can protect something that needs to be patented. And when you have a patent, you also have like a kind of a shorter window to protect it, because again, many things can be reverse engineered. And when you can bring an asset to the table like a patent, I mean, that is something that has great, great value. And people buy and license patents all the time. And again, those value, the valuation of a business based on the patents that they have are very, very great, especially because you can get international patents. So there's a business, my my company is working on, and they have several patents in both the United States and in Japan. And they're increasing they're increasing their patents in a few other markets, because now you had a patent in America, that's what, 300 million people, I think. Well, now we're over into Japan. Now we have access to, I think, what, like 1 billion people? Don't get me tied up on the population numbers, but additional markets.
So does the conversation then during negotiations come down to like a multiplier on the cash flow to say like, you know, hey, we've got this right in this new country and we're this size and we're worth this today, and the traditional, you know, revenue multiplier for a company like ours is 3 to 5x annual?
Yes.
Because of this IP, it should be 6.5 years why? Is that, or is that
Yes,
not?
definitely. I mean, it gives you great leverage. And of course, as you're talking about like the enterprise value and book value, which we could go down a whole nother rabbit hole on those, but those values are really pivotal in being able to put a company forward for a valuation, for a merger or an acquisition. And access to customers is very critical to that. And they've got to be able to compare themselves to another business that is similarly situated to say why they are, why their valuation makes one a difference versus another. One that's come up recently has been in professional sports. So the Boston Celtics and the NBA are now in the midst of finalizing a sale, and it's about $6 billion. The most recent sale before that was in the NFL for the Washington Commanders, which I think that one was exactly 6 billion. I think the Celtics might be 6.2 or something like that. But these are now all indications of what a professional sports team is worth. And legacy is something that plays into that. Of course, with the Celtics, they're the winningest franchise in the league, which certainly matters. I think they have 18 championships now. There are some teams that are, well, I think the youngest teams are probably like maybe 20 or so years old, but some teams it's impossible for them to even have that many, but that's not who they're comparing themselves to. They're comparing themselves to teams that are similarly situated, and that's how they're able to get to these valuations. There are certainly plenty of sports teams that could not even bring a $6 billion number to the table at all.
So there's a basis in calculation, but I guess at this
Yes.
point, when the IP comes into it, to me, it almost sounds like you're blending it with, I don't wanna use an insulting word, but I think like storytelling almost, you're
Yes, because
almost
that,
trying to communicate the value to someone on an
Yes.
as purchased basis, and
Yes.
there's no.
those things
validity of it.
absolutely matter. And what is, so I mentioned all the championships from that the Celtics have, and they did win last year. But before that, it had been a while. So, but it didn't matter, right? Because they have that legendary, they have that legacy. Whereas maybe a team that has won a little more often recently still possibly might, maybe they would get like a $3 or $4 billion valuation versus a 6 because of the storytelling. Those things matter because it translates to how you are perceived in the marketplace. And even another good example, a prime example, is the Chicago Bulls. You can go to many countries around the world and see people wearing Chicago Bulls stuff. We gotta credit that to Michael Jordan. Yes, they won 6 championships, which is only a third of how many the Celtics have won. But you can still see people wearing Chicago Bulls branded gear, and they haven't won a championship in what, like almost 30 years or so? The last 90,
27,
yeah,
28,
yes, yeah. So, but the Bulls, I think their valuation currently is about 4 billion or so, because
They can stand on their legacy.
they can stand on their legacy, and that story matters, which also means that they know that people are buying shirts off, not on Madison Street. And so that matters in a way that some other teams, you can go to Japan and nobody's wearing some other team, we won't say. So,
Okay, thank you.
so yeah. I think, what else? Okay, so we've talked about a good amount of these strategies as far as assessing your IP, and that's literally going through the things that you have within your business to determine if it's something that needs to be protected, and also how soon it needs to be protected. As I said, with patents, a lot of times you want to move as fast as possible and not sloppily, like get good patent counsel and find out if there is something that is already similar in the marketplace. Are you really in a very new space? You really need to do the research on it to make sure. But with patents, you have a little less, as we'll say, common law protection than you do with copyrights and trademarks. And that's using the C with the circle or the T with the TM superscript. Again, register the registerable and protect it at all costs. You want to be like Christian Louboutin, where it's like, I am on all of the, you got somebody who's on all of the social media platforms. You got somebody who's looking at all of the all the shoe websites, looking everywhere to make sure that no one is using your work of art in whatever way, copyright, trademark, patent, without your permission, because they can use it. They just need your permission and they should pay you for it. So it is really, really important to make sure you're doing that. The government will not do it for you. They will process the claims, but they will not, call you and say, hey, we see somebody using your stuff. You have to do that on your own. What else? Oh, and certainly use it. That is the best way, especially for trademarks, to make sure that you are building the legacy and telling the story and protecting your name and reputation in the marketplace is the very best thing that you can do for yourself. And as we talked about with like contracts and licensing deals and partnerships, et cetera, you want to make sure that you either have or you are, because I know there's lawyers watching this too, that you are able counsel, because it is really important. You don't want to, like I said, have a handshake deal and now something has happened and we don't know who's responsible for it because that wasn't determined in advance. And those are things later that translate to valuations for mergers and acquisitions, and when you really are putting yourself in that place of a liquidity event, because you don't want to have a bunch of lawsuits on your case, you don't want to have a bunch of insurance compromises or things like that because you didn't protect yourself through contracts, which is really important. And like I said, also for preparing for liquidity. So, oh, yes, question?
We do have a question online.
Okay.
Thank you for this, Victoria. It's very helpful. I have a couple practical questions, and that slide was good timing. My first question has to do with, how do you recommend effectively and efficiently finding and stopping infringers? And I ask this question because I manage an LLC that just primarily, although there is a copyright that we're working on now, but primarily has trademarks, and it's for a public sports figure. And the second an official product goes out with this sports figure's trademarked phrase, federally trademarked as well, in addition to partnership even with the team in a licensing agreement, though I should clarify, we're not partners, but everything that we do is licensing. We will see infringers. And even this big corporation has a very hard time just, finding and stopping these infringements. It's almost like not cost effective to constantly be on top of, although I know that we have the responsibility to be. So I'm just curious if you have any advice for finding and effectively and efficiently stopping this.
One way for finding, which is helpful with on the copyright side and a little bit on trademark, is Google alerts. And it sounds very like remedial, but not only will it tell you every time that this comes up on that Google can access, but it also tells you how it's coming up. But because how it's coming up isn't always necessarily an infringement, although sometimes it absolutely is. So I think the Google alerts will give you an indication of what could be or could not be infringement. The other way is definitely to use the indicators of how the, you said it was like a catchphrase and logos, be able to use the indicators in process of them being registered. Depending on who is doing the infringing, you absolutely want to send them a cease and desist letter. You start there because often that should be enough of a scare tactic. Sometimes it is not. For the other way I would assess it is whether it's really infringement or not, and also if it is compromising the brand in any way, whether that's financially or from a reputational perspective. That would be another way too. And I think it's really important also, like you said, the licensing agreements. If the team is one of the violators, there definitely needs to be a discussion there as well, as far as like
No,
why
no.
they're not, okay.
No, there,
Um,
just to clarify, I manage this LLC for a well-known former Pro Football Hall of Fame coach who has a very well-known phrase. And so he has, or we have, our own products with this phrase. And we've in the past couple of years, we've partnered with the team that he's well known for. And so we've got their logo and his phrase on these. And so I'm running, we run now even with our licensing partners, and we're now getting a lot more licensing partners. So that our licensing partners are not infringing by any means. In fact, when one of our shirts came out during this football season, the team licensing partner put it out on social media with a video message wishing the team luck, etc. And honestly, right on that team's social media, someone's like, you can get the shirt here. And I was like, oh my gosh, I cannot believe this infringer. And it's like on like TeePublic or these like, Amazon type, third-party sellers. And they just push them out like so fast.
Yes.
It's really hard to keep on top of everything. And no, sometimes just like 3 cease and desists don't work. And then what? You're going to sue them. It's going to cost more money. It's one of those things where in law where they really need to teach you more in law school. Like at some point you have to do a cost benefit analysis, even though someone's doing a wrong to you, you know what I'm saying? So I'm just like trying to figure out a way to kind of like automate this, find it, automate it, throw it out, and hopefully it stops.
Yeah, I think definitely the Google alerts and other automated tools to just tell you where it's popping up so that you can be able to assess which ones are actually of value. And because, if somebody's just reposting it for on their own kind of, not private page because you can see it, but on their own personal page, that's very different than, like you said, now they've got it up on Amazon. It's also very helpful to reach out to the platforms because they have means for protecting your brands as well, because these platforms do not want to be responsible for harboring infringement. So that's another way to go about it as well.
Yeah, we've been doing that, but I like your practical tip about the Google Alert, but I didn't understand the indicators second option that you explained.
Oh, so the Google alerts, but there's like a few other like AI tools that you can use that do something similar to that, where it basically like scans the internet based on what you want. Google Alerts is I think kind of the original maybe of that, but and I'm blanking on what the other ones are, but there are other tools that will like scan the internet for keywords or and like your catchphrase, which should be an easy one to be able to put in partnership with using Google Alerts.
Yeah. Okay, well, thank you. I wish there were, a cost-effective particular company or group that actually did this, and there probably are, but I don't think they're very cost-effective.
I'll get.
We're running a bit short on time.
Yes, sorry, we're short on time, but let's I'll give you my contact information and we can chat more because I just need to be able to process and think because there is another tool that you can use, but there's people waiting to get this room. So
Yeah, no worries. Thank you so much.
yes, no problem. Thank you.
Yeah, give like another, if I give any closing thoughts.
My only, I was going to share these tips. As I mentioned, the blog that I have, the baffleblog.com, which has a lot of helpful tips. The U.S. Patent and Trademark Office, they have helpful tips on their websites. They make it very clear, as do I, it's like we can't give you official legal advice because we're not your counsel, but tips are helpful. Same thing with the Library of Congress, the World IP Organization, business valuation resources, and that can help take you through different ways to value your business, including with intellectual property. And also locally here, the Lawyers for the Creative Arts, which helps creatives with legal matters. So that is all. Here's my email address for people who have questions. Kimberly, please feel free to reach out to me and anyone else who may have questions or inquiries about these matters. So, but thank you so much for your time. It's been really great. I'm glad this was a conversation and you guys have very, very good questions. So I really enjoyed this.